Hey everybody, welcome back to the internet where your cesspool is my jacuzzi. My name is Lauren Knighty and this is the Court of Random Opinion. I'd be quick. I'm going to quickly go over an update in the Owens versus Echard case. If you're newer to my channel from some other stuff I've been covering and you don't know much about this case at all, it's a really wild one. Definitely something that I've been heavily involved in and following as far as like content creation and all that goes. And it's kind of how I, started doing stuff like this on YouTube. So if you are not really following this, but you want to know what's going on in the background of everything, you can go to this website right here, Victims of Laura Owens. Give me 1 second to pull that up for you. Whoops, that's not what I meant to do. Okay, and you can find like pretty much everything that you would need to know on here. Of course, the subreddit Justice for Clayton is also a great resource. But anyways, this woman, Laura Owens, accused the former lead of The Bachelor, Clayton Echard, of fathering her twins and then basically being a bum and refusing to have anything to do with her and the babies. Turns out she faked medical records and she lied about a whole bunch of shit. And she has apparently been faking cancer, various medical issues, pretending to have been sexually abused to the extent of doing a TEDx talk, and also, faking twin pregnancies with multiple men for about a decade now, if not more. This has affected at least 4 or 5 different people, but we have, 3 who have come forward. There's Clayton Echard, the one who's unfortunately still dealing with this woman's appeal nonsense. There's Mike Marraccini and there's Greg Gillespie, who unfortunately she just renewed her fraudulent restraining order against Greg Gillespie. So I'll put a link to the fundraiser for him in the description as soon as I'm done here. So we have the new filing. I'm going to give it a quick skim over tonight just by myself because it is already 11 p.m. and I have some stuff I have to do before bed. And then I'll get a group together so that we can go over it together in more detail and all that, either later this week or this weekend, whenever it works for everybody. Hey, Brad, what's going on? I know Loud Little Ducky is going over the full thing tonight, so if you guys want to head over to her channel after this, she's reading the whole thing. So, but like I said, I'm just going to skim through it tonight. I have a couple of relevant things before we take a look at that. Nicole Scott here. Hey, what's going on? Hey, Dan. Hey, Sheeps. Okay. So we have here, this is David, the attorney for Laura Owens, and he said, let me move my head really quick. That is not what I wanted to do. There it is. Okay. He said, just got some interesting news from the Court of Appeals about Laura's motion for reconsideration. Short version, it's potentially good for us. I'll explain ASAP. And then here is the image here. It says, relating to the Laura Owens versus Clayton Echard order re-agenda MR response. I think that's like something reconsideration or motion reconsideration. And then he hasn't gone into any detail yet. But here on the subreddit, the Justice for Clayton subreddit, somebody posted this filing. And in the comments, it says he just tweeted about it. Wonder what his teaser is for potentially good news. Amamas Nanas says, hold on, Clayton's side has been asked to write a response to this motion for reconsideration. Can't wait for Marcus to rip him to shreds again. Marcus is the attorney handling Clayton's filings and all that in this appeal process. Mamas Nanas also says this is what his social media post is about. It's standard procedure. Petitioner is not special. And if you don't know, this is kind of an iconic line from some of Greg Woodnick's filings. So thank you, Mamas Nanas. I can only assume that's another name for tits. I'm not sure, though. All right. Anyways, this filing, you can find it on the subreddit and also here on the website. Again, that is victimsoflauraowens.com. She's currently apparently under investigation by the county attorney's office. I'm not positive, though. Hold on. Oh, thanks, Brad. I just got your text. Okay. So Brad just sent me this, the document he was tweeting about. It says, pursuant to motion for reconsideration ordered, the motion for reconsideration is taken under advisement. Response to the motion for reconsideration is due on or before May 5th. So that means Clayton is unfortunately going to have to rack up some more attorney's fees that Laura will eventually have to pay because, let's face it, she's a scammer. And there's no way the Court of Appeals is going to be cool with that. So yeah, we peer pressured her. We did it. What are you talking about, man? I see some more of you guys coming in here. Hey, how's it going? All right. Sorry, one sec. And like I said, we're not going to read this word for word tonight. I'm just going to skim over it with you guys just so we can take a look at it. And then if Ducky's still going after that, we might send you guys over to her. Give me one sec to take a look. Oops, forgot to edit that. Okay. I'll zoom in a little bit. Hopefully that's good enough for you guys to see. Okay. Introduction. Pursuant to Arizona rules for civil, I'm assuming that means appeals or something. Petitioner Laura Owens respectfully moves for reconsideration of this court's decision dated March 28, 2025. Laura understands reconsideration is rarely granted and is not an appropriate vehicle to rehash arguments previously raised and rejected. Sure, that'll go well. At the same time, Rule 22 allows the appellate court to consider whether its decision contained erroneous determinations of fact or law. Oh, so it's kind of like, he's going to try to gaslight them and be like, no, you were wrong. Would you like a cookie, perhaps, since Rachel didn't eat hers? Okay. Here, Rachel Juarez, if you guys don't know who I'm talking about, you should watch that Reality Steve podcast where he debates Rachel Juarez on there. I've only seen about half of it so far, and it was she wiped the floor with it, really. Okay, here the memorandum decision contains erroneous determinations of both fact and law, which directly affected the decision. For that reason, reconsideration is appropriate. Discussion A, the structural error analysis misstated Arizona law. Okay. In her appellate briefing, citing cases such as Marraccini versus Abersold, I still don't know how to say that name, Laura argued the trial judge violated the due process clause and committed structural error by considering extrajudicial evidence, and we all know what that was about. This court rejected Laura's argument for several reasons. Yeah, you could have just ended there. Due to the limited nature of reconsideration requests, Laura will not re-raise the same legal arguments this court has already considered. Well, thank fuck for small miracles. All right. Instead, Laura notes this court's own legal analysis of that point rests on an erroneous application of Arizona law. Specifically on page 10, paragraph 24 of its decision, after rejecting Laura's structural error argument, this court explained the law as follows. While a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias, apart from any structural error claim, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. And I can't even remember exactly what point they started accusing her of being biased, but it was really ridiculous. Hey, Slug, what's going on? I thought we were done hearing about Rule 26, but I bet you're right, Karen. Maybe it is in here somewhere. Maybe it's not. I don't know. Surprise me. This statement is incorrect. It contradicts the cited authority and is not an accurate statement of Arizona law. In fact, the cited authority requires reversal of the lower court's judgment in this case. Trust me, bro. That conclusion comes from the first case cited, which involved a defendant who worked as a legal secretary in the Yuma area. I don't care about that right now. We'll talk about that later when I do. We'll have like a panel where we go over this thing in full, and we'll talk a little bit more about that then. Maybe we can get Hito Izakura on there. We'll see. Okay. After accepting a plea, the defendant appeared for sentencing, where she asked the judge to disqualify himself, arguing bias. The defendant explained to the judge, I feel that you have personal disgust and animosity and hatred and maybe dislike for me, and that you are on a personal basis with the victim, which I believe could cause bias. I'm surprised she hasn't tried something like that. She loves to try to send the judge inappropriate communications. So she should probably do that. Just kidding. Please don't do that. And if you didn't know this already, in a case with one of her other victims, she tried to email the judge ex parte and tell them that the victim of hers and his attorney were under investigation by the FBI because they had sort of plotted some sort of weird attack on her. It was bizarre. And then they like to glaze over that and pretend it didn't happen or something. All right. I'm going to skim over this. Okay. Likewise, the other case cited by this court, Stagecoach Trials NHC LLC versus City of Benson, does not support the cited premise, i.e. that when judicial misconduct occurs, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. This misstates the holding of Stagecoach Trials. Unlike Emanuel, in this case, Stagecoach Trials did not involve judicial misconduct. Rather, the sole argument in Stagecoach Trials, or Trails, my bad, guys. Stagecoach Trails was the trial judge's, that's very confusing, Trails trial. The judge's rulings were too one-sided. Despite the well-settled rule that bias cannot be established solely by adverse rulings, the presiding judge granted a hearing and allowed the defendant to offer other proof of bias, which it failed to do. Okay. Laura's structural error argument was never based on judicial rulings alone. Okay. B, reversal is mandatory because the trial court failed to make the required statutory findings to support an award of fees under ARS 25-324 or 25-809. Okay, we're going to go with that again. The court is familiar with the procedural history of this case, so a full discussion is unnecessary except to note a few basic facts. The case began with a petition to establish paternity filed by Laura on August 1st. I noticed we're not including all the basic facts, which is that Laura faked the pregnancy and the medical documentation along with it. So, whatever. In the form pleading she filed, Laura checked a simple box asking the court to award reasonable parenting time. What is reasonable parenting time for blowjob babies that were made up? Laura also submitted a generic pro forma plan proposing joint custody with equal time. Joint custody of what? The sperm that you had in your mouth? Like, what the fuck? These two pleadings, Laura's pro se petition and generic parenting plan, are the only pleadings ever filed in this case where parenting time issues were raised or discussed in any substantive way. And that is two pleadings too many for fake babies. All right. In his pro se response, respondent Clayton Echard denied paternity. As for parenting time, Clayton's response was entirely blank. Well, why would you want parenting time when there's no babies to parent? Clayton never submitted a parenting plan of his own, hardly surprising given that no children were ever born, nor were they conceived. But let's leave that part out, huh? After Clayton retained counsel in mid-December 2023, the first substantive pleading he filed was a request to amend his response to Laura's petition. In that pleading, Clayton sought leave to add a request for Rule 26 sanctions, while also withdrawing his request for fees under ARS Section 25-809 and adding a request for fees under 25-324 based on Laura's general unreasonableness without any mention of parenting time. Does it matter if the parenting time was unreasonable? I mean, come on. I know I'm just clowning, but let's see. Withdrawing his request for fees under ARS 25-809. All right. Clayton's motion for leave to amend, ROA 33. It says, wherefore, based upon all the foregoing, respondent respectfully requests the court enter the following orders. A, issue an order declaring that respondent is not the natural father. Okay. And they cross out B here. C, issue an order compelling Ravgen Incorporated produce all records and documents related to fetal DNA testing in this matter. D, that this court sanction petitioner pursuant to Rule 26. And E, that this court award respondent his reasonable attorney's fees and costs based on petitioner's unreasonableness pursuant to ARS 25-324. Okay. Oh, thank you, Winks. I always forget that. Yep. One sec, guys. So did she ever claim that she was really an African elephant? And that explains the 22-month gestation period. Hey, Julia, what's up? Scorpion says, I'm so sick of this woman and her idiot lawyer. You lied, you lost, get over it. They want to take this shit all the way to the U.S. Supreme Court, and that is just a horrible abuse of the system, in my opinion. But all right. Okay. While parenting time was never litigated because no children were ever born, conceived, fix that for you, the issue of Rule 26 sanctions was litigated extensively and aggressively. Yes, that's putting it lightly. Just days after Clayton raised the issue of Rule 26 sanctions, Laura retained counsel who apparently had a single phone discussion with Clayton's counsel regarding Rule 26. The next day, on December 28th, Laura invoked the safe harbor provision of Rule 26 by moving to dismiss her petition with prejudice, explaining she was no longer pregnant. Well, she was never pregnant in the first place, so. Despite Laura invoking the safe harbor of Rule 26, and before, we're still doing this? We're really still doing this. And before Clayton's request to amend his pleading was granted, Clayton filed a motion for Rule 26 sanctions. This filing caused in the parties to spend nearly 4 months aggressively litigating the question of Rule 26 sanctions, but not parenting time, as that issue was moot by then, which eventually concluded when Clayton withdrew his Rule 26 motion on April 3rd. The record is clear. The parties did spend extensive time litigating Rule 26 sanctions, but spent no time litigating parenting time. For that reason, Laura took the position, both in the trial court and in this appeal, that the award of $150,000 of fees and costs must have been made under Rule 26, not ARS 25-324 or 809G. Well, that's stupid, but all right. Clearly, I'm not the only one who thought so. So, guys, the way this guy argues, and it makes me so mad, it's like he thinks it's totally fine for somebody to abuse the system like this and punish some guy for not, wanting to date her with a fake pregnancy and dragging him through the court. And then it's like, well, she said she wanted to let it go because she got backed into a corner and she was about to get caught. And she said she wanted to let it go and he didn't let it go. So it's his fault. He's making this drag out. It's his fault this is dragging out. It's his fault he has fees. It's not her fault at all, even though she's the one who abused him. Yes, abused him. Okay? Even though she's the one who abused him and abused the system that's meant to protect everyone in the county. Not only that, but took up specialist appointments that people who were actually pregnant may have needed. Okay, so this thing goes way beyond just somebody writing a frivolous, stupid parenting petition or whatever. She's wasted a myriad of resources that other people actually need for their legitimate medical conditions. And she does it to abuse others. In its memorandum decision, this court rejected Laura's position, concluding that because the trial court expressly awarded fees and costs under ARS 25-324 and 25-415, any discussion of Rule 26 was simply irrelevant and unnecessary. This aspect of the court's decision was incorrect as a matter of law for a separate reason the court appears to have overlooked. While this court correctly noted that Clayton generally asked for fees under other authority at various times, and while the court is correct that other statutes were generally mentioned in the lower court's post-trial under advisement ruling, this court overlooked the fact the trial court never made the specific statutory findings required to support an award under ARS 25-324. That fact, standing alone, requires reversal here. Prior to trial, Laura made a timely request for findings of fact and conclusions of law. Laura's request was clear. Yeah, okay. Well, so was the, ultrasound that she faked. It was clearly someone else's. So you're going to have to forgive me if I can't think of anything but snark when I'm reading this shit. Okay. Pursuant to Rule 82A1, Petitioner Laura Owens hereby requests findings of fact and conclusions of law with respect to all issues submitted for decision in this matter. Because Laura asked for findings, Rule 82A required the trial court to make specific findings on all issues of fact and law, including any fee award. To support an award of fees under ARS 25-324 based on unreasonable conduct, the trial court was required to make specific finding that the fees requested were necessary to the full and proper presentation of the action. The absence of that finding precludes an award of fees under 25-324. Okay. They're talking about State v. Torres here. I'm going to skim over. Like I said, we're going to go back over this later. Laura asked the trial court for findings of fact and conclusions of law, but at no time did the court make a specific finding that the $150,000 in fees claimed by Clayton were necessary to the full and proper presentation of any parenting time or paternity issues. Just as this court held in Torres, that omission mandates reversal of the fee judgment. To be sure, in the lower court's post-trial under advisement ruling here, the court noted purely as a hypothetical matter, fees may be awarded under ARS 25-324 if those fees are reasonable and if the court finds they were necessary to the resolution of the case. Laura does not challenge that general premise of law, but at the time of the lower court's under advisement ruling, the court had no factual basis to determine precisely what amount of fees, if any, were reasonable, or whether the specific fees requested were actually necessary to the disposition of the case. This is so because when the UAR was issued on June 17th, Clayton had not yet submitted his application for fees. Clayton's fee application was not provided to the court until weeks later on July 8th. Upon receiving Clayton's fee application, Laura raised extensive objections both in her motions for new trial and also her objection to Clayton's fee application. Yep, both very embarrassing, by the way. Among numerous other arguments, Laura's fee objection specifically reminded the court that fees could not be awarded absent a finding they were necessary. And here, the post-trial minute entry does not contain any finding that any of Clayton's fees or costs were necessary. Jesus. Nor is there any basis for such a finding. Rather than addressing Laura's objections and or making the required findings, the trial court simply ignored the issue. Thereafter, without Clayton even responding to Laura's objections on August 16th, the trial court awarded fees and costs in the amount of $149,219.76. This was error because neither the original fee judgment nor the amended version found the fees awarded were necessary to the disposition of either Laura's parenting time petition or the establishment petition. The trial court's failure to make those findings requires reversal. Because this court cannot make factual findings in the first instance, it is unnecessary to analyze these issues further. However, it is worth noting the lack of findings that Clayton's fees were necessary to the issue of parenting time is not merely an academic problem. This is so because while ARS 25-324 does permit a party to recover fees necessary for the resolution of parenting time issues, Clayton's fee application contains extensive time entries which clearly had nothing whatsoever to do with parenting time and thus could not have been properly awarded under ARS 25-324. This shit is shameful, dude. Like, imagine pushing this shit so far, knowing your client's lying. There's no way he doesn't know his client's lying. That's my opinion. Jason says she dodged discovery, provided contact info for medical providers she never received care from, and no-showed her deposition. All of these cost money. That's right. Yep. You think he'd be embarrassed by now, but I don't think he gives a shit. No, he really doesn't. But he should be, yeah. Okay. Like I said, we're going to skim over some of this stuff. To be clear, if Laura had not invoked the safe harbor of Rule 26, Clayton could have sought fees for time spent drafting and researching the Rule 26 motion. But Laura did invoke the safe harbor, and while Clayton had no basis to do so, he filed his Rule 26 motion and later withdrew it. These are not parenting time issues for which fees could be awarded under ARS 25-324. Here, the trial court never made the statutorily required findings needed to support the fees awarded, despite Laura requesting those findings, and despite her objecting to any fee award made without such findings. For that reason alone, this court should reconsider its decision to affirm the lower court's fee judgment and should remand this matter for such findings to be made and for any further objections to be addressed. C, the court also failed to make specific findings as to the amount of fees awarded under ARS 25-415. In her merits brief, Laura argued the trial court's award of $150,000 in fees could not be justified under ARS 25-415 on the basis that she violated a court order compelling discovery. I'm glad you guys are so proud of that one. Laura noted Clayton never sought relief under that statute, therefore she never had any chance to explain her side of the issue. Explain your side of the issue? Your side of the issue is pretty clear, bitch. All right. Like, you can try to squeak by like this in the court of law. That's fine. I understand an attorney wrote this, but again, this is not. I'm not a lawyer. I'm looking at this from a public opinion perspective, and this is terrible. The fact that you're even defending this and trying to drag this guy through appeals court again. Okay. This court dismissed that argument with this terse conclusion. Here, the court made such a finding, thus it was required to sanction Owens for the cost and reasonable attorney fees Echard had incurred. Owens does not meaningfully challenge that finding. Again, the court did not err in awarding Echard his costs and reasonable attorney's fees. Okay. Laura maintains there was no factual basis for the finding that a discovery violation occurred. Okay. But even if she was wrong, that does not end the inquiry. I'm going to skim. Okay. As noted above, because Clayton did not apply for fees until weeks after the trial court issued its under advisement ruling, the trial judge had no way of knowing what specific amount of fees, if any, Clayton claimed were caused by the alleged discovery violation. Similarly, at the time of trial, Laura had no way of responding to the specific details of Clayton's discovery-related fee claim because those details were not yet known. As such, the trial court's UAR under advisement ruling contains nothing beyond sheer speculation that Laura's alleged discovery violation is that a joke? May have caused Clayton to incur some fees. Are you out of your fucking mind? You would have to be so stupid. Oh my god. Until the court was provided with the actual fee application, it could not have found, and never did find, that any of the fees sought or awarded were actually caused by the alleged discovery violation. That error separately mandates reversal and remand, and I can't wait to hear the response to this bullshit. Well, for the reasons stated above, the Court of Appeals should reconsider its decision in this matter. Okay, well, their response, I guess, is due on May 5th, so that gives David plenty of time to try to sue people on YouTube in the meantime. Okay. That's all we got for now, folks. Hang on. Karen Carson, thank you for the 5. I said the other day, Laura may have invoked the safe harbor considerations, but she did not call Ollie Oxenfree, therefore sanctions. All right, let me see if Loud Little Ducky's still on. Yeah, one sec. Yeah, she is. I'm going to send you over to Loud Little Ducky, who's reading this whole filing right now. Please tell her Lauren sent you and hello. And I will see you guys soon. Like I said, we'll come back and we'll go over this again in full with a panel of us, and it'll be more interesting because I am tired of this bullshit. So, all right. Thanks, everyone. Appreciate it. Why is the court even asking for a reply? Well, probably for the memes, because you know I'm going to find some. All right. Bye, guys.